So here we begin our 3 classes on wills. This one is about will execution, that is, the execution ceremony, making the will formal by complying with all of the requirements. All states recognize a will that is signed by the testator and witnessed by 2 witnesses. One state, Louisiana, also requires a notary. In the second part of today's class, we're going to get to another form of will, the holographic or handwritten will, that is acceptable in some but not all states. Here's quite a fundamental question. Why do we need a Wills Act with formal requirements for a will? Well, one reason is that if we let every written statement by the decedent into court regarding his estate, we get this problem. How does the testator know that his conversations, his letters, his drafts, etc. won't be treated as his last wishes, or at least confuse the issue of his last wishes? And how does the court know what were the testator's actual last wishes? So I have this slightly fake multiple choice question. The answer is B, and D is just a joke. But the issue I want to raise is that we have this other evidence, A and C, both provide some evidence of what the decedent wanted to do with his estate. And I'd like you to distinguish between intent to make a posthumous gift and intent to make a will. That's going to come up later in today's lesson. In example A, we know that Sarah Lockhart intended to give the clay painting to Mitchell. But does she intend this document, this letter, to be her will, to stand up in court? Almost certainly not. If that was what she intended, she did a lousy job of implementing her intent, because everyone knows that this is not what a will looks like. B is the right answer. We know that Sarah wanted this document to be her will because she complied with all of the formalities, and this is the document that will be probated. Here's just a little vocabulary for you. The proponents of the will are the people who offer it to the probate court as the testator's last will, and they have to prove the will. That's not proof in the scientific sense, but it means to demonstrate that it was the decedent's will and that it was properly executed. This is the opportunity for challengers to step forward if they have evidence that the will was forged or coerced. And once the will is proved, then the executor can begin distributing the assets. The Wills Act is what we call the jurisdiction's requirements for a valid will. Every state has a Wills Act, or rather it's a section of the code that describes the requirements for a will. The ceremony of signing and witnessing the will is the execution of the will. It sounds simple enough, so here are the rules of a basic, sort of standard example of a Wills Act. The will must be in writing, it must be signed by the testator in the presence of 2 witnesses, and those 2 witnesses have to attest to and sign the document in the presence of the testator and of each other. So, as I said, it sounds simple enough, but almost every word in the Wills Act has generated its own body of case law. What is writing? What is a signature? What is presence? What is a witness, or who is a witness? Now, the book offers Langbine's article with some arguments that tough Wills Act requirements, that is, that the document must be in writing, must be signed and witnessed, are not pointless exactly. They do offer some protection to the testator against second guessing after his death, and forgeries that might be offered to the court, and so on. And I use the analogy of a wedding. So the mere fact of having a ceremony that's unique and maybe slightly awkward puts everyone on notice that this is serious and helps people remember in the future that it happened. So a wedding ceremony, you don't go through it lightly, you invite all your friends, a lot of people remember it, there are pictures. Well, that's not exactly the same as a will execution. It's a little less formal than a wedding, but it's a fairly awkward, unusual, once in a lifetime or once in a twice in a lifetime event, and people tend to remember it. They're certainly on notice that this is a big deal, that it's serious, and it sets this event apart from all of the other promises and letters and so on. So Langbein says the Wills Act requirements are meant to protect the testator by putting him on notice that this is what counts, and to provide some guarantee that more casual documents aren't going to be probated. But the Wills Act does raise the fundamental paradox of so much formality that a number of wills fail because people forgot to, or overlooked, or made some minor slip with respect to one of the many, many elements of the will requirements. I was just saying that the rigid requirements can form a trap because one tiny slip can cause the will to fail. So if a witness sneezes and steps out of the room to get a tissue, just at the moment that the other witness signs, then buzz, the will fails. And this textbook is unusual in that the cases in the book are not here as models for you to follow, but examples to scare you. There are a lot of very unfair outcomes in the book where the Wills Act has been applied rigidly and clearly the wrong person inherited the estate. These things can happen. There are people who challenge a will and they will search with a fine-tooth comb for some violation of the Wills Act, and therefore you have to prepare, really follow the rules incredibly carefully to make sure that there are no errors or slips along the way. Now, the Uniform Probate Code it takes a very liberal view of will execution on the grounds that the strict rules which were meant to protect the testator end up backfiring. So the UPC says we're not worried here, we're not talking here about cases where there was a forged will. We're talking about cases where the testator thought he was doing everything right, and some minor error, which really is not material, causes the will to fail, which means the property goes to someone else, someone the testator didn't want to benefit. So the UPC asks, what is really important? What's really important is that the will is in writing, that the testator signed it, and that the witnesses saw him sign, and that they acknowledged his signature. And what the UPC is willing to dispense with is the requirement that all of that happen in the same room at the same time with everyone watching one another. So the UPC's very liberal Wills Act says that the testator can go to witness A and ask her to sign, and then later go to witness B and ask him to sign. And either one of them can even hang on to the will for a while before signing. They don't have to sign in the testator's presence. This is the first of a run of 4 slides on the question of conflict of laws. That is, whether a will that was properly executed in one state will be recognized in another state. So suppose you wrote your will in New Jersey and then you retired to Louisiana. Would the will still be valid in Louisiana? When you died, would it be probated by the Louisiana courts? Well, yes, definitely, if it complied with Louisiana's Wills Act. So if Louisiana had the same requirements as New Jersey, it would recognize your will as valid. I chose Louisiana because it has a strange Wills Act. It requires 2 wills and a notary. So you might or might not have complied with Louisiana's requirements when you executed your will in New Jersey. What if you didn't? What if your New Jersey will did not comply with Louisiana's particular rules? Well, then what happens next depends on whether Louisiana recognizes a will as valid if it was valid in the place where it was executed. So that would be something like full faith and credit for Wills Acts. If Louisiana did have a rule like the UPC, which is the one on this slide right now, then it would recognize a will as valid if it was in compliance with the UPC, or the law of the place where the will was executed, or the law of the place where the testator was domiciled, either at the time of execution or at the time of death, basically everywhere that's relevant. However, not all states do recognize out-of-state wills that don't comply with their own particular rules. And where that causes problems is someplace that you might not have foreseen. And that is if a citizen of, say, New Jersey owns real property in another state, because real property has to go through probate in the state where it is located, even if the owner lives elsewhere. And that separate probate proceeding in the state where the real property is located is called ancillary probate. Ancillary probate. So I want to discuss this question of whether a will complies with the Local Wills Act in connection with real property, as I mentioned, because the law of the domicile governs the distribution of personal property, and the law of the situs of real property governs the distribution of real property. So I've switched here to Ohio because I have a proper map of Ohio and not one of New Jersey. You live in Ohio, and you have a second home in Kentucky. Well, that second home is going to pass under Kentucky's probate law. Now, the first rule, that the descent of personal property is governed by the person's domicile, seems obvious. So the probate court in Ohio, here, supervises the transfer of all of your personal property in Ohio, and your real property in Ohio for that matter, and also the furniture that you inherited from your parents that's still in a storage facility in Connecticut, and the jewelry box that you left at your sister's house in Pennsylvania, and the bank account that you happen to have in New Jersey. The whole point of probate is that all of the property is brought under one umbrella for probate purposes, for the convenience of the executor and the executor and the beneficiaries and the creditors of the estate. The odd rule out, actually, is that the inheritance of real property is governed by the state where the real property is situated. And this vacation house in Kentucky, who inherits that house is determined by Kentucky law. And as I mentioned, you have to go through probate in Kentucky, which is called ancillary probate, and that's on page 469 of the book, confusingly, way ahead of us. So that's step one. Kentucky law applies. Step two is, what is Kentucky law? Well, when it comes to the rules of intestacy, which we discussed last time, Kentucky applies Kentucky intestacy laws. So the personal property in my example passes under the intestacy rules of Ohio, and the real property passes under the intestacy rules of Kentucky. When it comes to the will, if the testator has spelled out what he wants to happen to that house, Kentucky could go one of two ways, as I mentioned on the last slide. It could say, sure, we recognize the Ohio will if it was valid under Kentucky law, or it could say, we recognize the will if it was valid in the testator's home state of Ohio. Now, if it does require the will to comply with Kentucky law, and the will does not do so, then in Kentucky's eyes, the testator died intestate. The will fails, and the property passes under Kentucky's rules of intestacy. So in that case, the testator died testate in Ohio, and that his will governs the personal property, and he died intestate in Kentucky, and that Kentucky's intestacy rules govern what happens to the house. So again, the issues are, is it real property? If so, it must go through probate in Kentucky. What law will Kentucky apply? Well, its own rules of intestacy if the person died intestate, and maybe its own rules of will execution, but maybe it will accept a will that was validly executed in Ohio. Conflict of laws was on the bar exam in the summer of 2019, and specifically the issue was the way real property is treated differently from personal property. And here's basically the sample answer and the way it stated the rule. So the lesson you should take away from all of this in terms of writing wills is that when you execute a will, you should comply with all of the requirements of all of the 50 states. Even though New Jersey's Wills Act is pretty lenient, you should go the whole hog. You should have the maximum number of witnesses, you should comply with all the presence requirements, you should be sure that the testator signs before the witnesses, you should do everything according to the strictest possible rules so that no matter where your client dies and no matter where he or she happens to have real property, that will be recognized as valid. So in this course, we have to look at the whole universe of Wills Act requirements and learn from the following horror stories what happens if the will drafter slips up even remotely, even minutely. The rules regarding presence are both picky and varied. Leaving aside the UPC for the moment, the general rule is that the execution ceremony must take place all at once in the presence of all of the parties, so that there is eyewitness testimony that everything happened exactly as it should. The testator signs first or acknowledges his signature. Acknowledging the signature, what does that mean? It means that the testator signed before the ceremony began, or even after it began, but he wasn't seen doing it, and he shows it to the witnesses and he says, "This is my signature." That's perfectly okay. The witnesses then sign in the testator's presence and in the presence of each other, which is great, except it raises the question of what is presence. They absolutely have to be in the same physical space. The states differ on whether they have to be able to see each other sign, to see the testator sign and to see the other witnesses sign. If they do, it's called a line of sight jurisdiction. Alternatively, in some jurisdictions, it's enough that they're in the same space, that they know through all of their senses what is going on, and that's called a conscious presence jurisdiction. But in either case, they must all be together physically. So witnessing a signature via telephone or via video or Skype does not count. The UPC is the outlier, of course. The witnesses must see the testator sign or acknowledge, but they don't have to see each other sign, and they don't even have to sign in the testator's presence. The testator can show the document to one, and that person can take it away and sign it later, give it back to the testator. He can then show the document to witness 2, acknowledge his signature again, and witness 2 could sign. So the spacing of the signing has become much looser, much more flexible. The reading and the multiple choice questions address the question of what counts as a signature, and the answer is whatever the testator intended to be a signature. If the testator initialed the will with the intent of signing it, that's okay. Now, where is the signature? Ordinarily, the signature is at the end. When you sign a document, that's automatically where you turn to. 8 states require the signature to be at the end. If it isn't, either the will fails, that is, it won't be probated, or the state simply designates the signature as the actual end of the will and probates only what came before the signature. But most states recognize a signature anywhere on the document, if it was intended to be a signature. A tricky case is the testator's name handwritten in the exordium, that is the opening of the will. This is a bit of a stretch because, in this case, Gary Smith may simply have been writing his name rather than signing, but generally it is accepted as a signature, unless, of course, there is evidence that the document was not meant to be his final will and testament. A codicil. I'm sure almost everyone knows what a codicil is. It's an update or an amendment to a will. If you want to make changes to your will, you can redo the whole thing, or better, you can append changes to the existing will. But don't go marking up the document. That won't have any effect at all. The will is going to be probated as it was at the time of the execution ceremony. It doesn't take account of any changes made to the document later. So, this addition or amendment is called a codicil. The codicil must be executed with full Wills Act formalities. It must be in writing, signed in the presence of the witnesses, and the witnesses must sign in the presence of each other, the whole shebang. In fact, a codicil is a mini will, and when I talk about a will and Wills Act formalities, I mean a will or a codicil. Who is qualified as a witness? Well, traditionally the witnesses had to be disinterested. That is, they wouldn't inherit under the will because who could trust such a witness? An interested witness has an incentive to lie about the testator's capacity to make a will, or even to defraud the testator into making the will in the first place. What kind of a witness is that? So long ago, the fact that one of the witnesses was interested caused the will to fail. That's no longer the case anywhere. Instead, we make sure that the interested witness has no interest. That is, we allow him or her to act as a witness, but deprive him or her of any benefit under the will. And that is done by what's called a purging statute, purging the witness of his interest. But then, this problem often arises when someone makes a will at home and has the kids witness it. The kids are exactly the people whom the testator wants to benefit, and a rule that purges them of their interest has exactly the wrong effect. Therefore, many states have what's called a lesser of two statute, or I call it a lesser of two statute. The witness gets what he would have had in intestacy or what he gets under the will, whichever is less. So he can't be better off under the will. Signing the will doesn't improve his position, but it doesn't necessarily leave him with nothing. The UPC, as usual, says this rule causes more harm than good. Let's just give an interested witness the bequest under the will, and maybe the fact that one of the witnesses was interested will come up if there's a charge of undue influence. It's been adopted, the UPC has been adopted, or this portion of it has, in about 1/3 of the states. There isn't much to say about this slide. It simply repeats what I was explaining on the last slide, how a lesser of two purging statute works. Say, Professor, what are those witnesses doing when they sign the will? Well, Billy, they are attesting that everything went according to order, that the testator stated that this was his will, that he signed or acknowledged his signature in their presence, asked them to witness his signature, and that they signed in the presence of each other. So, reverting to my own persona, that's what the witnesses' signatures mean. Now, ideally, the document would spell that out. It would include an attestation clause, as here. It isn't necessary, but it is clear and it is hard for the witnesses to contradict should they, for some reason, claim not to know what it was they signed. The idea of a self-proving affidavit has most people stumped at first, and I'm glad we discussed what it means to prove a will, namely to document that the will was the testator's last will and testament and that it was properly executed. Technically, when you prove a will, you bring the witnesses into court, if they can be found, or if they are out of state, get an affidavit from those witnesses to do what they would have, to say what they would have said if they were present. Wait, why don't we do this at the time that the will was executed? Well, we don't actually want to probate the will at the time it's executed. For obvious reasons, you might want to change it later on, but we could get the affidavits and we could attach them to the will itself. In fact, we can prove the will on the spot and come to court later with a fait accompli. So a self-proving affidavit does that. We add this affidavit to the will in which the witnesses state that the testator said that the document was his will, signed in their presence, and asked them to sign all of the things that they would testify to in court. Then the witnesses sign this statement and it is notarized to make it official. It all seems very redundant, but it could have a big advantage. See the next slide. As I just mentioned, when your executor goes to the probate court to prove the will, he usually needs to bring in at least one of the witnesses. And if the witnesses cannot remember the execution ceremony, the attestation clause gives the executor the advantage. There is a rebuttable presumption that everyone complied with the signature requirements. And if there's also a self-proving affidavit, well, then there is a conclusive presumption of compliance with the signature requirements. So since the attestation clause and the self-proving affidavit basically say the same thing, some states, that is, allow a combo, two documents in one, and that's called a one-step self-proving will. That's the end of this set of slides. You'll move on to part 2.